If you lost a loved one and they didn't have many assets, you may be able to settle their estate quickly and affordably through a process called disposition of personal property without administration. It's Florida's simplest form of probate. In this video, I'll walk you through exactly how to file for disposition without administration step by step. Let's get started. So the first step is to make sure that you actually qualify. Disposition without administration is only available when the decedent did not own real estate in their name alone. The only assets are either exempt personal property under Florida law, like household furnishings or a couple of vehicles, and or non-exempt assets that are less than the funeral and final medical expenses paid by the person filing for disposition of personal property without administration. So if your loved one only left behind a small bank account or a refund check or some personal items, and you paid for their funeral, you likely qualify. Before you file, you'll need to collect the following documents. You'll need a certified copy of the death certificate and a copy of the paid funeral bill and proof that you paid it, such as receipts or canceled checks. A list of the decedent's remaining assets, including account statements, refund checks, or personal property info. And you'll also need a copy of any medical bills from the last 60 days of the decedent's life. You'll need your ID and contact information. And if you're not the sole heir or the only person entitled to the asset, you'll also need a signed affidavit of consent from anyone else who might have a legal interest in the decedent's asset. Next, you'll complete the petition for disposition without administration. You can usually find this form or a packet on the Clerk of Court's website for the Florida county where the decedent lived when they pass away. Some counties allow online filing, while others require you to submit the petition in person or by mail. The petition will ask for your name and your relationship to the decedent. It will ask for a list of the decedent's assets and their value, and it'll ask for the amount of funeral and medical expenses. Who paid what is important. Whether any of the probate proceedings have been filed in any other state, and you need to be truthful and accurate. You're signing under penalty of perjury. Once the petition is complete, you file it with the probate division of the Clerk of Court in the correct county. You'll need to include the completed petition, the certified death certificate, proof of the paid expenses, and supporting documentation of the decedent's assets. You'll also need to pay the filing fee, which is usually around $230 to $270, but this varies by county. Some counties allow you to submit everything online through their e-filing portal, while others might require you to go in person or mail the documents. Call the probate clerk or check on the website for that county to confirm the procedure. Once your paperwork is filed, a probate clerk or judge will review it. If everything is in order, the court will issue an order of disposition, which allows the bank or other institution to release the funds or property to you. This usually takes a couple of weeks, but some counties are faster or slower depending on their workload. Let me give you a few quick tips. Make sure the asset you're claiming is titled in the decedent's name alone and not jointly owned. Don't try to use this process if real estate is involved. It won't work. Double check that the expenses exceed the value of the assets, unless you're claiming exempt personal property only. If you're ever unsure, contact the probate clerk's office or consider having an attorney review your documents for a flat fee. You need to keep in mind that the court clerks are not permitted to give you legal advice. So if you go ask a legal question and they don't answer it, it's not because they're being mean, it's because they're not allowed to answer legal questions or provide you legal advice. Thanks for watching. I hope this walkthrough makes the process of filing for disposition without administration in Florida a little less intimidating, but if you run into questions or need help, feel free to visit costpluslegal.com or reach out to my office at 239-220-3100. Be sure to subscribe or check out the rest of our probate video library for more helpful Florida estate guidance. Take care.